Sikshayati, platform for eminent authors, engaging teachers, successful students. To know more, email. Contract without consideration. Though consideration is essential in a valid contract, however, in certain cases a contract is valid even without any consideration. This is exception to the rule no consideration, no contract. Time-barred debt. Time-barred debt is normally unenforceable. However, a time-barred debt becomes enforceable if payment of time-barred debt is promised in writing and signed by debtor or specifically authorized on his behalf. Example, A took loan of rupees 2000 from B 5 years back, which he did not pay. The debt is now barred by limitation. So B can no more sue A for the time barred debt. A now promised in writing to pay B rupees 1000 towards the past debt. This is a valid contract of the new promise to pay rupees 1000 and A must pay rupees 1000 to B as per contract. Now, if A does not pay, B may sue for recovery of rupees 1000 as promised. Agency. No consideration is necessary to create an agency. An agent may enter into a valid contract even if there is no consideration for him. That is, even if agent is not taking any commission. Example, A appoints B to sell his house, giving him a power of attorney. B makes contract with C to sell him the house on behalf of A. Held, the contract is valid if it is made by B within his authority, even if B does not get any commission or benefit out of the deal. Promise for past voluntary services. Normally, no liability arises for voluntary act, as consideration must flow from promisor. However, a promise to compensate past voluntary services is enforceable even without consideration. Example, while B is away on holiday, a storm damages the roof of the house. A, his neighbor, carries out the necessary repairs. On his return, B promises to pay A for the expenses of repairs. A can recover the money from B. If B did not promise to pay, B is not bound to pay, but he became bound by his subsequent promise. Bailment. Bailment is temporary transfer of possession of goods to another. Consideration is not necessary to effect a valid bailment of goods, called gratuitous bailment, like delivery of valuables to neighbor for safe custody, lending bicycle to a friend for his use, etc. Charity. If a person promises to contribute to charity and on his faith the promisee undertakes a liability not exceeding the promised subscription, the contract shall be valid. Example, X promises Y, the owner of a temple, to donate rupees 50,000 for renovation. On the promise, Y incurred expenses for renovation. Held, X must pay Y for expenses incurred up to rupees 50,000, though there was no consideration for X. Remission. Where a person agrees to receive less than what is due to him, such an agreement is remission. No consideration is required for a contract of remission. Example, A owed B rupees 5,000. B agreed to accept rupees 4,000 in full settlement of the debt. Hence, B must accept rupees 4,000 to settle the debt. Guarantee. A contract of guarantee is a contract to perform the promise of discharge the liability of a third person in case of his default. A contract of guarantee is not valid if made without consideration. However, the consideration received by the principal debtor is a sufficient consideration for the surety, and the contract of guarantee shall be valid if no consideration is received by surety. Example: P requests C to sell and deliver the goods on credit. C agrees if S promises to guarantee to payment in default of P. This is valid contract as there is no consideration between P and C, though S did not receive any commission or benefit of guarantee. Agreement with relatives. Agreement with relative having bad blood relation or relationship out of marriage, made in writing and registered out of natural love and affection, is enforceable even without any consideration. Example: out of love and affection, X promises his son to give rupees 1 lakh and executes a deed. It is valid contract because the contract has been done out of natural love and affection between the parties, though there is no consideration for X. Contract with seal. A contract made in the form of a deed under seal is valid even if it is made without consideration. Gifts. In case of completed gift with completed document as necessary, consideration is not needed between donor and donee. Hence, a contract of gift even without consideration is valid. Example: A executed a deed to gift his house to B. This is valid as it is made in writing and executed as per law. Thank you for watching the video. Kindly write your comments. Click on the red subscribe button at the bottom of the video to get more details and free ebook. Email us.